regionally protective criteria or through protective site-specific criteria. The policy contains guidelines for evaluating whether a proposed diversion in combination with existing diversions will impact flows needed for fishery protection using either an individual or a watershed-based approach. The policy contains limitations on construction of new on-stream dams and approval of existing on-stream dams. And the policy contains enforcement requirements, including a framework for compliance assurance, prioritization of enforcement cases, and descriptions of enforcement actions. The State Water Board previously adopted the policy and certified the associated CEQA documentation in May 2010. The associated CEQA documentation consisted of a substitute environmental document, or SED. The SED evaluated the potential environmental effects of policy adoption. The policy has no direct environmental effects. All of the environmental effects are indirect as a result of actions that affected persons might take to avoid or comply with the policy, including affected persons switching to groundwater pumping to avoid the policy's restrictions on surface water diversions. The SED was circulated for public review and comment in 2007 and 2008. In 2012, the SED and in particular the mitigation measures associated with affected persons switching to groundwater pumping was the subject of a court case from Living Rivers Council. Ultimately, the Alameda Superior Court identified 2 inadequacies with the SED and issued a writ of mandate directing the State Water Board to do 3 things. Vacate the decision to adopt the policy and certify that the SED was completed consistent with the CEQA guidelines. Evaluate certain subterranean stream delineation maps as a potentially feasible mitigation measure for the potential increased use in groundwater attributable to the policy. And present sufficient information to allow the public and decision makers to consider meaningfully and understand the limited legal options facing the State Water Board to mitigate for the potential increased use in groundwater. To comply with the first requirement, the State Water Board issued a resolution in October of 2012 to vacate the policy and the decision to certify the CEQA documentation. The resolution also directed staff to revise the SED to address the inadequacies identified by the court. Accordingly, staff revised the 2008 SED document. The revisions included edits to the impact analysis to clarify that the potential switch to groundwater pumping is unlikely to have a significant impact on surface flows, an evaluation of the feasibility of adopting the subterranean stream delineation maps as a mitigation measure, clarifications concerning the State Water Board's authority to regulate groundwater use pursuant to the constitutional and water code provisions for waste and unreasonable use and the public trust doctrine, clarifications concerning local agency regulation of groundwater in the 5 counties, and updates to the mitigation chapter to include mitigation measures that were included in the final 2010 SED. Revisions were incorporated into the impact analysis concerning the potential switch to groundwater pumping because the 2008 analysis was misleading. The State Water Board action analyzed in the SED is the adoption of the policy. Policy adoption does not have the potential to cause diversions to occur, but it can influence the source of water diverted. The revisions to the impact analysis explain that the potential shift from surface water diversion to groundwater pumping that could be caused by the policy is unlikely to cause an impact to surface water flows. Specifically, staff considered that where a surface water diversion responds to policy adoption by switching the source of water diverted, switching to groundwater pumping under circumstances where surface water would normally be diverted, the increases in groundwater diversion would be offset by the surface water diversion that would otherwise occur. In cases where the groundwater well is in an immediate connection with the surface water stream, the impact can be expected to be similar but not more than the impact that would have otherwise been seen from the surface water diversion. In cases where the connection is diminished, the impact can be expected to be diminished. In cases where there is no connection between the groundwater well and the surface water stream, no impact would be observed. Staff also considered that a switch to groundwater diversion could be associated with a delay in impacts to surface water streams. This delay could result in an environmental impact, particularly in the summer months. The more closely associated a groundwater well is with the surface water stream, the less likely there is to be a delay. Also, diversions from groundwater wells can be recharged by other sources of water. Staff considered these concepts along with information regarding policy area, hydrology, geology, water diversion and use in assessing and concluding that the potential switch to groundwater diversion as a result of the policy is unlikely to have impacts on surface water streams. The revisions clarified but did not change the associated impact analysis. With respect to the court's second requirement to evaluate the feasibility of adopting subterranean stream delineation maps, staff considered relevant factors in concluding that adoption of the maps is infeasible. Specifically, staff considered the speculative nature of affected persons switching to groundwater pumping, the revised impact analysis, which concluded that a switch from surface water diversions to groundwater pumping is unlikely to impact surface water flows. The small percentage of geographic area, and planned and existing diversions covered by the area delineated as subterranean streams on the delineation maps. Staff considered one example map in which the majority of planned and existing diversions, or 92%, were located outside of the boundaries of the subterranean streams identified on the map. The extensive time and high cost associated with map adoption, staff estimated a range of potential resource investments needed to refine the delineation maps and consider them for adopting. In so doing, staff considered potential focus areas and the associated characteristics, previous state water board proceedings to delineate subterranean stream areas, and the requirements of rulemaking. Staff identified a low range estimate of 3.6 years in time and 1.3 million in costs, and an upper range estimate of 12.8 years in time and 5 million in costs. Staff also considered that the subterranean stream delineation maps can be used on a case-by-case basis to determine the state water board's permitting authority over a given diversion, whether or not they are adopted, and the state water board's authority to regulate groundwater pursuant to the wasted and unreasonable use provisions in the public trust doctrine. With respect to the court's third requirement to present sufficient information to allow the public and decision makers to understand and consider meaningfully the limited legal options facing the State Water Board to mitigate for the potential increased use in groundwater, staff clarified the limitations with respect to the board's permitting and regulatory authority, and also clarified that while the counties may mitigate for groundwater use pursuant to their police powers, most are unlikely to do so. On February 22nd, the revised sections of the SCD were circulated for public review and comment. The written public comment period closed on April 8th, and a hearing for the receipt of oral comments was held at the State Water Board meeting on April 23rd. Comments were received from Trout Unlimited, National Marine Fisheries Service, North Coast Stream Flow Coalition, Mendocino County Farm Bureau, Kimberly Burr, Carter, Momsen and Knight, and the Living Rivers Council. A late comment letter was received from the California Department of Fish and Game. Staff considered and developed responses to all comments received. Responses to the on-time comments were posted on the division's website in early October. The comments raised a variety of issues. One issue that was common amongst some of the comments was a misunderstanding that the revisions to the SCD were somehow suggesting that groundwater is not connected to surface water, or that pumping groundwater has no potential to impact surface water flows. This was not the case. The revisions to the SCD were intended to tease out the impacts of policy adoption from the impacts of groundwater pumping in general, and clear up the misleading 2008 analysis. Staff has attempted to further clarify in the responses to comments. No significant revisions to the policy have been proposed based on the revisions to the SCD or the comments received. The revisions to the policy consist of minor clarifications and corrections. The revised policy with the minor clarifications and corrections noted was posted for public review and comment on October 4th. The written public comment period ended on October 17th at noon. One on-time comment was received from Trout Unlimited in support of policy adoption and recertification of the CEQA documentation. One late comment was received from Living Rivers Council. This comment was styled as a reply to the response to comments document. It largely reiterated the earlier CEQA comments submitted by Living Rivers in April. The reply did point out one mistake in a table included in the response to comments document. Staff would like to correct that mistake and have provided an edited response to comments at the back table and to the board members. The edit deletes the table and deletes one sentence discussing the table. These edits do not change the overall response to comment. Staff have prepared a draft resolution with attachments, including a CEQA findings document, a mitigation monitoring and reporting plan, and a statement of override. Staff recommends that the State Water Board adopt the draft resolution, which certifies the CEQA documentation and in turn adopts the policy. This concludes my presentation. Thank you for your attention.
Questions? All right. Well, let's move then to comments. There are a number of people here. I have one speaker card. Thomas, is it Lippy? Lippy, thank you, from Living Rivers Council.
Thank you, Chairperson Marcus. I had asked for 7 minutes in my card.
Yep.
Am I going to be allowed?
Yeah, that's fine.
Thank you. First of all, on the timing of Living Rivers comment letter, I received the notice of this proceeding by an email which had a link to the web page on your website about this policy, which states that comments are due on October 17th. It doesn't have a 12 noon cutoff on that date, so I put that in my calendar, and that's what we relied upon, and didn't look further into the web page to look at other documents for an additional information on the comment. So I would encourage the board to accept that. I think legally the board's stopped from not accepting it as timely because of the reliance on what the web page said. But, and also just another legalistic point is that CEQA's deadline for comments on a CEQA document is before the close of the public hearing. And so from that standpoint, it was timely. But more from a policy standpoint, I think the argument there does reiterate some of the environmental points that made in the comment letter on the draft EIR, but there's a lot of legal argument in there as well, which, as you know, we're going to go back to the judge in Alameda Superior Court, and those legal arguments will be presented there. There's not a legal requirement that I present them to this board, but I did want the board to have the opportunity to look at them, consider them, and so I would ask that the board consider them before we go back to court, just as a matter of policy and efficiency. One other issue I wanted to bring up here today is that the substitute environmental document revision reopened the impact analysis. And that's very interesting because the response to comments says that the board doesn't have to consider any mitigation measures except those specifically identified by the court in its remand order. Well, the remand order doesn't authorize or direct the board to reopen the impact analysis. So you can't have it both ways. You have to either stick to the position that only what the court authorized or directed can be done here, in which case you can't reopen the impact analysis. I think the other implication or the other consequence of reopening the impact analysis is that
That's just giving you a
little
time
warning.
signal, but it's fine.
Okay. Living Rivers Council spent thousands of dollars on legal services to analyze the revised SED's reopening of the impact analysis. And that reliance on that stops the board from then saying on the mitigation side that we are limited to what the court told us to look at. So if you're going to reopen the impact analysis, we relied upon it. The mitigation analysis is reopened as well. And Living Rivers and other people suggested many mitigation measures, and the response in part was we don't have to think about the feasibility of these because they weren't in the court order. I think that's legally wrong. Now, one of those mitigation measures in comment number 33 and 34 by Living Rivers Council was that when someone applies for a surface permit, surface diversion permit, if they have a well, they should be supplying information to the board about that well sufficient to allow the board to determine if it's affecting stream flow. And the response to the comment was, well, there's no nexus between the well and the surface permit. But there is a nexus, because when you do your CEQA analysis of the permit application, the well is part of the environmental setting, and it's a past project. And so the CEQA requires information on that to determine if the permit is going to combine with that past project or that environmental feature of the environmental setting to cause significant impacts. And so there's a very clear nexus between, and certainly the Stetson delineations and the board's own statements in these documents, that there is a connection between groundwater withdrawal and stream flow. So finding out if that connection exists in any one place is certainly within the board's authority under CEQA. Now, the other concept that's in the response is that somehow the severity of the significant impact is related to the feasibility of mitigating it. And that's a new idea under CEQA. It's not part of CEQA law, and it's simply not legal. And so that's a false premise for this board to make any decisions about the feasibility of mitigation. Now, it may be that if the impact is less severe but still significant, which the documents say it's still significant but less severe than we previously thought, that lack of severity may determine how much you have to mitigate. And CEQA requires that you mitigate where it's feasible, where the mitigation substantially reduces, and that you have to do it as long as the impact remains significant. So maybe the impact doesn't remain significant quite as long if it's less severe, but it doesn't change the fact that you have to mitigate to the extent feasible. And so our comments go into great detail on why some of the mitigation measures are feasible, including the one I just mentioned about getting information on wells from permit applicants. Now, one of the themes of the documents prepared by staff is that there's no mitigation measure that's going to completely reduce the impacts of groundwater pumping on stream flow to less than significant. Well, that may or may not be true, but it's not really relevant to the obligation to mitigate. As I said before, the obligation is to do so to the maximum extent feasible as long as there's a substantial reduction. So the fact that you can't solve the problem entirely doesn't mean that you're not legally required to do what can be done.
Mm-hmm.
And one of the other mitigation measures is comment KB4 suggested using the Stetson delineation maps to establish areas where groundwater pumpers have to prove that they are not are not drawing water from subterranean streams or not affecting stream flow. And the response was, well, we don't have the authority to do that because the assumption under the law is that people are pumping from percolating groundwater, and the board would bear the burden of proof. But the Pomeroy decision and the North Gualala decision, which is what the board staff relied upon, both provide that the burden of proof can be met by evidence that consists of reasonable inferences from the available information. And that's what's used in these cases. Nobody knows what's really going on under the ground. You have to make reasonable inferences, and the Stetson maps are reasonable inferences based on the available information. So you do have the authority, and Living Rivers Council would encourage you to use it rather than take the approach which we see in the documents, which is that the board's hands are somehow tied. The board has vast authority here, and what the documents reflect is really a policy decision not to proceed to use it, and Living Rivers Council would encourage you to take a different approach. Thank you.
Questions? I have a couple. Yeah, if you have questions, yeah.
Sure.
You go first.
In that last comment, I perceive maybe
It's a
some.
question for the we have one more speaker, just so
Oh,
you know.
okay.
But
Well, maybe
you
this
can
is
go
for
ahead,
staff.
and then we have one more
This
speaker.
is for staff, just to on that point. In my reading of the materials and all the responses to comments, I didn't read it exactly how the commenter, Mr. Lippy, read it in terms of our hands are tied. My reading of our response, and correct me if I'm wrong, is that we can rely on materials such as the Stetson maps and make reasonable inferences in permit decisions. But this analysis is of the policy, not of specific permitting actions. So I didn't read that we said our hands are tied in those instances where there's a technical question of connectivity. So am I reading that correctly?
Yes, you are. I believe the comment that Mr. Lippy was just referring to was a suggestion that the board should impose a reporting requirement on groundwater pumpers to prove to us whether or not they're affecting surface water streams. And in response to that comment, we pointed out some of the limitations in the law with regard to the legal presumption that groundwater is percolating groundwater. That isn't to say that we can't use maps or any other information that may be available on a case-by-case basis that may indicate to the contrary, that either that a particular groundwater user is subject to our permitting authority, or that their pumping may be unreasonable or in violation of the public trust doctrine.
Yeah, I sense that theme of there's some confusion, in the back and forth about whether the policy creates this problem, or really if, we're not giving up any, or the question of whether through this SED analysis we're somehow giving up some kind of authority to ask those very pertinent questions. And so thanks for confirming what I believe to be the case, which is through the policy adoption, we still have authority to pursue those questions and create accountability. Thank you.
Another speaker, Chris Milan from Institute for Conservation Advocacy, Research, and Education.
Thank you.
And you asked for 15 minutes. Do you need 15 minutes?
I don't
That's
know.
kind of a lot. So
Yeah.
why don't I give you the same
Two
7 as
people here.
him, and then I can be gracious at the end if you're almost
Sure.
done. Okay.
Sure.
Just for fairness.
So, yes, my name's Chris Malin, and I'm the Executive Director of the Institute for Conservation Advocacy, Research, and Education, and actually the North Coast Streamflow Coalition is a project there, but I'm not speaking on their behalf. We already submitted a letter. And this, really my comment is to speak to you as a unique board, a board of great significance, because you are at a time in history where we have reopened water right applications, and 1914 when we started this, and almost 100 years later, and we're looking at it again. I don't think we're going to get another opportunity in the near future to revisit groundwater and its impact on streams as it relates to water diversions. So I think that we need to do it right this time. I do coordinate with a lot of other stream activists on the North Coast, from San Francisco Bay all the way to the Oregon border. And we all have the same concerns. We are the folks that are actually in the streams and in the watersheds on the ground in these streams, looking at the fish and looking at the watersheds. And we are quite alarmed at groundwater impacts. And this is from empirical observations over the years. And we've noticed that when you hike a stream, there are a lot of groundwater wells pumping, and we can see them and hear them pumping as we're hiking. I myself, on the Napa River, have kayaked the entire river, and I've been shocked at the number of groundwater wells that are close to the stream. And over the years, I have seen salmonids stranded in isolated pools and groundwater wells pumping. I've watched these fish die in the pools, and it leaves an impression. I'm not the only one. Like I said, other activists have seen this too. So we would ask that the board really take a serious look at groundwater impacts and take this opportunity, as the legislature has asked you to do, to protect wildlife as it relates to groundwater, as it relates to water diversions. And we know that there are a lot of groundwater pumps out there that are not included in the cumulative impact analysis when a person applies for a water right permit. That oftentimes that flies under the radar. And so we are hoping that this policy can rein in the fact that there are other impacts coming to the stream, to the surface water through the groundwater, and that when a person applies for a surface water diversion, and if they find that the regional criteria is onerous and that there really isn't water available coming down, it's very easy for them to go to groundwater. And the application process doesn't rein in on that currently. There's a lot of important work that could be done to bring that into the purview of the Water Rights Division. I think that the policy is going to miss its mark. It is not going to protect wildlife and fish anadromy and keep it from going extinct if we don't look at watersheds as a unit that functions together between surface water and groundwater. And unfortunately, the policy won't work if we don't look at it as a watershed system that relies on surface and groundwater being there to keep water in the stream. For us, it's not just about the fish, it's about us and going into the future. And with climate coming the way it is, we need to be extremely careful about how we proceed, because our watersheds are our lifeboat. That is where we live. And if we can't rely on the streams and rivers in our communities to sustain us during catastrophic climate events, we're doomed. We have to have clean flowing water, and it has to be there for the future for us. Thank you.
Thank you very much, and thank you for bringing it back to the purpose of why we're all here. Very well said. A question. Do you have, can I move a question for staff on a couple of things? I mean, there's a distinction between programmatic environmental documents and what level of detail you can get to versus a case-by-case look. And I don't think we're trying to say that we wouldn't be doing those things, but can somebody, either Dana, you or Michael or Katie or Tom or Karen, just pick, oh, we have one more speaker, which is fine, talk about the various tools we can use to be dealing with this, because we are spending a lot more time thinking about groundwater with our groundwater strategic plan and figuring out precisely how to get the tools together to deal with these sorts of issues across the state, not just in the North Coast. So can you talk about the interplay of the basket of tools we have with this particular policy and this particular document? You guys can flip a coin. I mean, all of you can address it, I'm sure.
I'll just say that the analysis that was done, the CEQA analysis that was done in connection with this policy was fairly limited. The intent was to evaluate the effect of adopting the policy. That's our project from a CEQA standpoint. And we were also faced with the challenge, you mentioned the word programmatic. We don't really know how people are going to react to the policy. And we indicated in our response to comments that when it was adopted back in 2010, we didn't observe a wholesale movement to groundwater pumping. We're aware of one instance where someone did that either in reaction to the policy or just to avoid having to get a water right permit generally. Which isn't to say that there might not be more examples out there, but you know, we really were focused on what the effects of this particular action could be, and it's somewhat speculative. The very nature of the analysis is inherently speculative. There is a larger problem with groundwater pumping in this region, and that is really separate and apart from the analysis that we were doing in connection with this, with the in-stream flow policy.
Right, that's what because I know we're trying to focus much more on groundwater and take it very seriously for a lot of the same reasons as the last speaker presented, and I was writing down, it's very well said. And so what I'd like is a little bit of a sense of what are some of those other tools we're looking at so that anyone listening knows that we're not, I think and maybe I'm oversimplifying, but the argument seems to be, do we use this policy to solve all of those problems? Or do we get a basket of tools together so that we can deal with this in the case-by-case basis? Because it is going to vary by area. And what my sense is that folks in looking at the policy would like us to wrap more of it up in a bow than we have, and arguably maybe we could have, or maybe we couldn't have. I'm most interested in just articulating how we are going to deal with these issues, or trying to, within the limited resources that we have right now, even as we keep trying to get more resources on this.
So we fully agree that there are public trust impacts in many parts of the states associated with low flow, and that's a combination of surface diversions and groundwater diversions that are causing the problem. On the North Coast area, I think groundwater diversions are a particular concern. You know, the way we're trying to address this, and it's, you know, it's quite a task, in all honesty, but we are trying to, we're working with the Department of Fish and Wildlife. We have an in-stream flow task group. We have formed a public trust function here at the State Board that didn't previously exist. We are working to establish in-stream flow objectives in a number of streams presently, and it's an effort we expect to continue and expand. As we set these in-stream flow objectives, we are then going to have to look at the various alternatives we have to achieve them, and my opinion is that in many cases, especially on the North Coast, we're going to have to get into the issue of groundwater pumping. We aren't going to achieve our objectives by curtailing simply surface water diversions in many cases. You know, many parties have decided that you know, putting a well into gravels associated with a stream is a much more viable alternative than surface water diversions in any event, but the impacts to the surface flows are, you know, in many cases close to 1-to-1. So we'll be continuing this. We've presently, just as an example, we just recently sent a report over to the Delta Stewardship Board, the Science Board, laying out the methods that we intend to be using to set in-stream flow objectives and asking for their opinion. Some of them are meant to be ones that will not require us to look at every stretch of stream independently, but will instead be able to look at watersheds as a whole and a distributed flow objective system associated with that. You know, I see this as an activity that the Water Board's going to be moving more and more resources into over the next few years, and I hope to make a great deal of progress in it. With respect to this policy, you know, to a certain extent, the focus was what type of permit conditions should we be putting on the existing applications that are out there. We had, when this bill was adopted, we had some 350 pending applications in that area, and they were completely gridlocked because nobody could seem to figure out what type of conditions should be put on those permits that would be sure to protect the stream flows, and so that was the focus of this policy. But now we do have this much larger issue of how to deal with public trust flows in these streams, and a systematic way of starting to address that.
Could you expand on the groundwater work plan as well? Because that's related, I think.
Yes, well, Karen's been working on that, so I'll let her say a few words on that.
Right, so very recently we put out a draft concept paper that we've been circulating, one for comment, but more importantly as a means of establishing some stakeholder dialogues around the state to look at how should we, in a holistic manner, be approaching groundwater across the state. We've put out a general management framework, and then within that management framework, of course, there are key elements: establishing thresholds, monitoring and assessment, having governance structures, providing adequate support through funding, monetary support, and then, of course, enforcement to do what we say we're going to do. And we have a variety of activities that we've shown that are currently ongoing in the state, not just that the water boards implement, but that other state and local entities implement as well. And then we have put out a series of proposed actions as a means of getting a dialogue going. And within the, just as an example, within the fifth element, enforcement and oversight, one of the ideas for discussion is looking at ways to integrate the various tools that you were talking about, Chair Marcus, the various, whether they're enforcement authorities or other tools, to be able to address the oversight needed with respect to groundwater in the state. And so we're seeking input on that action as well as other actions across the concept paper itself. So what we're hoping from that process is that we'll be able to get a general picture of what are the most important things that we need to have within our groundwater framework. And then for the water board specifically, what are the changes we need to make to the programs we currently implement? What are the new things potentially that we should be doing in concert with local and regional actions, which are really so important because these are local and regional issues.
Right. Well as our colleagues at Fish and Wildlife, right, with other state agencies.
Absolutely.
Too. I can't remember. I know I've looked through it, but what does it talk about the notion of the connection between surface and groundwater?
Yes, it does
Yeah, I just
speak
forgot
to, the
that part of it.
concept paper is a fairly abbreviated version of a larger document that we hope to put out sometime right after the first of the year. But yes, it does speak to the interconnectedness.
I have another speaker. Okay, I'll go and then more questions. Jack Rice, Associate Counsel, California Farm Bureau.
Good morning. Thank you for the chance to talk. Jack Rice, Associate Counsel, California Farm Bureau. Just wanted to offer support for adopting the policy for the simple fact that AB 2121, which I had been engaged in for several years as it was coming up to in its adoption in 2010, and we weren't particularly pleased with the result, but it was what was decided, so that's what we were going at. But the whole purpose of it was to provide a means where folks could get off-stream storage and a way for it to happen because, as Mr. Howard pointed out, that system was gridlocked. And so there's a need still out there for people who are not trying to take water in a way that'll hurt fish, but are actually trying to get water in a way that'll help fish, but do it in a manner so it can actually happen and they're not caught in a 10 or 20-year process.
That's right.
Without even going to the groundwater issues, that's an important need, and our understanding was that that's what this policy was intended to do. With that, the only other comment is that I know the Division of Water Rights has been working really hard because this policy is technically very difficult to deal with. I mean, there's just a lot of requirements there, and it's hard to find water and get it. That administratively, it's really important that it work as smooth, be as efficient as possible. The Division of Water Rights has done a really good job changing it and approaching that way, and we just encourage the board to continue to support that because if you add administrative difficulties on top of technical difficulties, then it's truly sometimes insurmountable. So thank you.
Thank you. There are questions?
Well, yeah. You know, I appreciate your remarks, Chair Marcus, and I was thinking along the same lines. And also, as Mr. Howard recounted, you know, what's ahead of us in terms of flow objective work at the regional level and the state level, it also made me think of things we have done, you know, before I've been around. But there are many statewide cases where the connection to groundwater, to surface water, was very central to the decisions that have been made. And so we have some good groundwork to build from. But, you know, I just want to acknowledge the commenter's concerns about this issue and just to assure you that I share those concerns. And maybe just build on one of your comments and just allow staff to maybe respond to it. Anyone who would like to step up. But the concept of the existing groundwater pumping that's happening. So not necessarily as an outgrowth of policy and how behavior might change, but just to speak to the issue of, you know, you're hiking up your favorite creek and you see the well next to the stream. If we're going in and doing a permitting action there, you know, are these existing pumping systems flying under the radar in our process? And are there things we can do to, within our existing framework, to, as Chris Malin pointed out, rein in the groundwater pumping as part of a watershed analysis of the proposed diversions? So this is a very valid concern, you know, notwithstanding all of the legal arguments that are going on. And how are we addressing that now? And, you know, and then Mr. Howard pointed out there are things we can do within, say, water quality objectives and you know, changing our permit process to incorporate those water quality objectives. That's something we can do in the future. But how about now? How can we assure folks throughout the state that are concerned about dewatering that's occurring? How is that going to be taken into account in these permitting processes?
I like that you came with your nameplate, Andy.
In case
Do
I
you carry
forget
that with you
who I am,
everywhere,
you can introduce
you know?
me as Andy Sawyer, Assistant Chief Counsel. As the policy and substitute environmental documents state, our legal authority is much more limited as applied to percolating groundwater than to surface waters and subterranean streams. I wanted to bring up, we do have authority, of course, under Article 10, Section 2 of the Constitution, Water Code Section 275 and the Public Trust Doctrine. The bigger problem is funding. We are a fee-supported program in the Division of Water Rights. Those fees are charged to permit and license holders. We can't spend substantially more on regulation of people not subject to the permit and license program than we get from sources independent of fee revenues. So as a practical matter, additional work we do on groundwater pumping that is not from subterranean streams has to come at the expense of work we're now doing to regulate riparian and pre-14 water right holders, or we have to find a new source of funding. Within that limited funding constraint, which is an even bigger problem than the legal constraints, there are things we can do. A good example is the Russian River Frost Protection Regulation, which addresses not just surface diversions, but also diversions for interconnected groundwater. We are, of course, spending resources defending that in court against challenges by people who say we don't have that authority. We are looking into what we can do in areas like the Scott River. We're dealing here with a potential impact. We have other areas where we have well-identified impacts in terms of our strategy to deal with groundwater. I think we need to focus on where the impacts are greater within our additional resources, and then we should be looking for additional sources of funding and additional legal authority. Unfortunately, both those processes to get a budget change proposal for more funding or legislation are confidential, so we're not in a position here to tell you what we are doing in that area. But certainly I would encourage the board to look in both areas for additional funding and additional legal authority to deal with what we all recognize is a very serious problem, is that groundwater and surface water are closely connected. And the permitting and licensing program doesn't reflect that, but instead has a very outdated classification system that's inconsistent with what everybody knows is the science.
Right. I think here's one of the issues I think that came up as I was reading this, and I was somewhat comforted by the response to the comments, is that, and I've been in this situation in doing programmatic documents where you're talking about more narrow issue. That it did sound like we were minimizing the powers that we did have. And that was of concern to me too. When I read it, the response to the comments reassured me, and that's why I'm asking the questions I'm asking, to assure folks that we're not giving up on any authority that we do have. you've explained some of the challenge in prioritization, but it does make it sound, particularly as the speakers say, you know, if you have a well that's right next to the stream, then we do have authority over it if it's drawing from a subterranean stream. We just have a challenge in going after it, and we're going to prioritize it when it comes up and we see an indication, as opposed to making a blanket programmatic statement, which I think is completely appropriate, though people might want us to say it. And I think that just the assurance that we're going to keep trying to figure out how to grow our ability to deal with this, particularly in the cases where you see a connection between the groundwater and a stream, I think is an appropriate thing for us to say and talk about where we see the more appropriate tools to go about going after it, in addition to trying to get more resources, which I completely agree with. All right. Any other questions? Okay, with that, do I have a motion? Okay, do I have a second?
Second.
Any?
So, and the motion was to adopt the resolution that includes both the CEQA document as well as the associated readoption of the policy.
And any changes on the change sheet?
Correct. And just to be clear, the change that was read into the record is not part of the resolution, just for clarity of the record. It is part of the responses to comments.
Right.
So.
Okay.
Did you second?
I second.
Any comments? All in favor?
Aye.
Okay. Thank you. It's carried, and thank you to our all of our speakers. That was helpful. Thank you very much, and we'll look forward to working with you in every forum on every front. And I'm going to quote you. That was good. Mr. Howard, do we have anything else? Janine, do we have anything else? Are we set? Okay, with that, it's been a pleasure, and we'll see you next time.